Welcome viewers. The ex-president's supporters will no longer be able to avoid testifying before grand juries in Washington, D.C. and Georgia. In this video, we will break it all down for you. But before we continue, please take a minute of your precious time to hit the subscribe button below and turn on the notification bell to get the latest update from us. A spate of major court rulings rejecting claims of executive privilege and other arguments by Donald Trump and his top allies are boosting investigations by the U.S. Justice Department, DOJ, and a special Georgia grand jury into whether the former U.S. president broke laws as he sought to overturn the 2020 election results. Former prosecutors say the upshot of these court rulings is that key Trump backers and ex-administration lawyers such as ex-Chief of Staff Mark Meadows and legal advisor John Eastman can no longer stave off testifying before grand juries in D.C. and Georgia. They are wanted for questioning about their knowledge of or active roles in Trump's crusade to stop Joe Biden from taking office by leveling false charges of fraud. Due to a number of court decisions, Meadows, Eastman, Senator Lindsey Graham and others must testify before a special Georgia grand jury working with the Fulton County District Attorney, focused on the intense drive by Trump and top loyalists to pressure the Georgia Secretary of State and other officials to thwart Biden's victory there. Similarly, court rulings have meant that top Trump lawyers such as former White House counsel Pat Cipollone, who opposed Trump's zealous drive to overturn the 2020 election, had to testify without invoking executive privilege before a D.C. grand jury investigating Trump's efforts to block Congress from certifying Biden's election victory. On another legal front, some high-level courts have ruled adversely for Trump regarding the hundreds of classified documents he took to his Florida resort Mar-a-Lago when he left office, thus helping an inquiry into whether he broke laws by holding onto papers that should have been sent to the National Archives. Trump's multi-pronged efforts to keep former advisors from testifying or providing documents to federal and state grand juries, as well as the January 6 committee, has met with repeated failure as judge after judge has rejected his legal arguments, ex-Justice Department prosecutor Michael Zeldin told The Guardian. Obtaining this testimony is a critical step, perhaps the last step, before state and federal prosecutors determine whether the former president should be indicted. It allows prosecutors for the first time to question these witnesses about their direct conversations with the former president. Other ex-justice lawyers agree that Trump's legal plight has now grown due to the key court rulings. Favorable rulings by judges on issues like executive privilege and the crime-fraud exception to the attorney-client privilege bode well for agencies investigating Trump, said Barbara McQuaid, a former U.S. attorney for Eastern Michigan. Legal challenges may create delay, but on the merits, with rare exception, judges are consistently ruling against him. Although Trump has been irked by the spate of court rulings against him and his allies, experts point out that they have included decisions from typically conservative courts, as well as ones with more liberal leanings. Former federal prosecutor Dennis Aftergut, for instance, said that just last month, the 11th Circuit Court of Appeals, one of the country's most conservative federal courts, delivered key rulings in both the Fulton County and DOJ Trump investigations. Specifically, the court in separate rulings gave a green light to DOJ criminal lawyers to review the seized, classified documents that Trump took to Mar-a-Lago, reversing renegade district court Judge Aileen Cannon's freeze-in-place order, Aftergut said. In the other ruling, the court held that Graham couldn't hide behind the Constitution's speech and debate clause to avoid testifying before the Atlanta grand jury, Aftergut noted. The speech and debate clause, he pointed out, only affords immunities from testifying about matters relating to congressional speeches and duties. That dog didn't hunt here. Soon after these rulings, the Supreme Court left both orders in place. Please, what is your take on this? And remember to subscribe as well. Thanks for watching.